Right.
Whenever you're ready, counsel, you may proceed.
Good morning, Mr. Slater.
Good morning.
How are you?
I'm good.
Okay, we're going to start with just some background questions. Who is subject to the suit? How are you related to them?
She's my daughter's mother,
Okay, and who's your daughter?
Aura.
And how old is she?
She's 4.
And were you ever married to Miss Brooks?
No, ma'am.
Okay, and so you were never married. Were you in a relationship?
Yes.
Okay, and when did that relationship end?
Probably a little bit before Aura was born.
Okay, and how was your visitation like before that?
It was okay.
Okay, and then at some point you decided you needed to get an order in place, correct?
Yes, ma'am.
Or you guys decided, and so that's the order that's currently in place.
Yes, ma'am.
Okay, and how has visitations been going since that order's been in place?
It's been okay, but not through the whole order.
So let's talk about you allege 13 different violations. Is that correct?
Yes, ma'am.
Okay, so let's talk about the first one. The first violation you stated occurred on Saturday, November 16th. Is that correct?
Yes, ma'am.
Okay. Can you look at what's been previously marked Exhibit 1?
Mm-hmm.
And at that time, it's a Saturday. Why is it a Saturday that you're picking her up?
Because the judge that gave us the black and white, the court order.
Mm-hmm.
She gave us a first 90 days at 10 to 11 or 12, and then the next 90 days from 11 to 12. So
So you had like a step-up schedule?
Yes, ma'am.
Okay, and now where are you at in that step-up schedule?
We're on the regular court order.
I'm going to object as relevance because,
Okay, that's fine. I can get to the point. I was just trying to get.
Sustain.
well, we're on the second amended motion and that's not a date that's listed. Oh,
Sustain.
okay, all right, sorry. Okay.
Go ahead.
So this has been previously marked as Respondent's Exhibit 1.
Yes, ma'am.
And what's going on in that text message?
I'm letting her know that I'm here and that I'm picking up Aura, and then that there's traffic on the highway, and I'll be a little late.
And what time did you get there?
I got there at 10:11.
And was she there?
No, ma'am.
Were you able to see your daughter that day?
No, ma'am.
Okay. Let's move on to Exhibit 2, previously marked Respondent's Exhibit 2. What's going on that text message?
I was asking for Aura to be dropped off. I was seeing where Aura was.
Were you supposed to get her that day?
Yes, ma'am.
Did you?
No, ma'am.
Let's turn to Exhibit 4. That's a Thursday, correct?
Yes, ma'am.
Tell me about what's happening in that.
I was letting her know that I'll be picking up Aura at 6 o'clock.
And what happened with that?
I didn't get her.
And why not?
Because majority of the time, she said Aura's not in school, so she's not going by the school time to pick her up or getting her on Thursdays.
Okay, so tell me about the school. What was your understanding of the school?
My understanding was wherever she lives, even if she's in school or not, that she goes by the school that's around her.
Okay, and what time did you think the school around her got out?
4.
And why did you think that?
My wife and I called the school, and the lady at the front desk told us 4 o'clock was their dismissal time.
Action, hearsay.
Sustain.
So you did some research,
Yes, ma'am.
and to the best of your knowledge, it was at 4?
Yes, ma'am.
Okay, and so if you turn to Exhibit 5, Exhibit 6 of Respondents, Exhibit 7, all of those, if we go all the way through them, all the way to throughout the exhibit through Exhibit 9, those are all on Thursdays, correct?
Yes, ma'am.
And you're there around 4.
Yes, ma'am.
Okay, did you later find out that it was actually 3:15?
Yes, ma'am.
And how did you find that out?
We were in court.
Okay, so did Mom ever tell you, hey, no, it's 3:15?
No, ma'am.
Was she ever there at 3:15? Where are you?
No, ma'am.
Did you ever, was there any communication about the time?
No, ma'am.
And so you showed up when you thought it was the time, correct?
Yes, ma'am.
And to your knowledge, did she ever show up?
No, ma'am.
And you were never able to get your daughter on those days?
No, ma'am.
And then, again, in Exhibit 10, that's the same thing, a Thursday. Is that correct?
Yes, ma'am.
Okay. And so you listed 13 violations throughout. Let's look at Exhibit 11 really fast.
Okay.
That one's actually on a Friday, not a Thursday. Is that right?
Yes, ma'am.
And you're there at 5:57 p.m. to pick up your daughter?
Yes, ma'am.
And what happened then?
We were supposed to pick her up because that was first Friday, and it was the first Friday of the month, but the days kind of got shifted. But she said it wasn't.
So you said this is the first weekend in February?
Yes, ma'am.
And she said, take a look at your calendar and you'll see it's the first one.
Yes, ma'am.
Was it the first one?
No, ma'am.
So did you get to see your daughter that entire weekend?
No, ma'am.
That's not a pleaded for.
Sustain.
Let's look at your requested summary of relief. Go to ours now. This is what you're asking the court to do today, is that right?
Yes, ma'am.
So you're asking, number one, that she's violated the possession and access order. Is that right?
Yes, ma'am.
You're asking for a suspended commitment. Why do you think that she's going to violate this again?
Because even with communication, it hasn't been good. So it's always back and forth, not communication on a positive note, but back and forth on another note.
Okay, so how many times have you not been able to see your daughter?
About 13.
Okay. And so you're just asking for her to be put on a suspended community service or commended community supervision for 5 years to make sure she continues to comply with these orders?
Yes, ma'am.
And you're also asking for your makeup days.
Yes, ma'am.
And that's what's most important to you, correct?
Yes, ma'am.
Okay. And so if you look at the calendar that's been previously marked P5, and I know it's not in color for you, but I know you've seen it in color, correct?
Yes, ma'am.
And then is that kind of just outlining the days that are yours and then the days you would like makeup days for?
Yes, ma'am.
And that would be if it had started tomorrow, correct?
Yes, ma'am.
Okay. And so you're just asking the court for makeup time?
Yes, ma'am.
And then and everything else listed in here, that's also what you're asking, but your primary concern is just makeup time for your
Yes, ma'am. Makeup time.
Okay. And then you're also asking for attorney's fees, correct?
Yes, ma'am.
And you, and is there anything else you would like to ask the court today?
No, ma'am.
Okay, that's all the questions I have for you.
Okay, pass the witness. Counsel, pass the witness.
Oh, yes, pass the witness.
Okay, Attorney Granada.
Thank you. Mr. Slater, when did you first learn school let out at 3:15?
We're in court after I filed for.
April of this year.
Yes, ma'am. Sir.
And then you admit, I think when your lawyer was asking you questions, that on all of your alleged violations, you did not go to the pickup location at 3:15, correct?
Yes, sir.
Okay. So you just admitted you didn't appear for any of these violations, right?
No.
You know, you don't. So if you just said you didn't appear at 3:15, then help me understand why you're now saying you didn't. You appeared. I'm trying to understand.
Appeared at 3:15.
Okay, but you're trying to get her in trouble for not appearing at 3:15, right?
No.
What are you trying to get her in trouble for?
Not giving me or.
Okay, but the order says at the time school lets out, which is 3:15 for your admission. So how is she going to get in trouble?
That was after the court date.
And you learned in April, yet you're still going forward with your petition for enforcement today.
So
You had learned that school got out at 3:15 in April of this year, yet you're still going forward with your petition for enforcement today for makeup time. Okay, for periods of time that you didn't show up at the proper time, right?
No, sir.
Okay. And you want attorney's fees today?
Yes, sir.
Okay. And you want suspended commitment, I believe you said?
Yes, sir.
Okay. Do you feel like your conduct would be a justification for the court assessing attorney's fees against you?
No, sir.
You don't think that you, by not showing up at the time school lets out, that this lawsuit is frivolous?
No, sir.
I'm gonna pass witness.
Okay. Counsel, is there anything further from your client?
Just a couple. You showed up at the time of what you thought was when you were supposed to pick up your daughter, correct?
Yes, ma'am.
So even if you picked her up at 4, you still showed up
Yes, sir.
and no one was there.
Yes, ma'am.
And there was no communication of why.
Yes, ma'am.
And she never showed up at 3:15 either.
No, ma'am.
Okay. No further questions.
Okay.
So I don't understand why you're asking for makeup time if you're the one that didn't show up at the proper time.
Object, is that a question? Are we crossing again? Asked and answered.
Overrule. Counsel, rephrase that question.
Mr. Slater, I don't understand why you're asking for makeup time if you admittedly didn't show up at the proper time to pick up your daughter.
Because I was there at 4.
But you're in the wrong. You didn't go at the proper time.
Not from what I was told.
Okay, but you understand the legal time is 3:15, not 4.
Sir.
You don't understand that?
No, sir. That's what I was told.
What time do you believe your possession starts now?
My possession starts now.
On Thursdays and Fridays?
And Thursdays after she gets out of school.
And what time's that?
That's around 3. Well, we get there early, so.
I'm gonna pass the witness.
Okay. Anything further?
Nothing further for this witness.
Okay. Sir, you can have a seat back next to your attorney. Counsel, you may call your next witness.
I'll call Ms. Brooks.
Okay. Ms. Brooks, you may have a seat right here. Just make sure you pull the microphone close to you.
Okay.
Okay. Counsel, whenever you're ready.
Ms. Brooks, do you think it's in the best interest of your son to spend time with his dad?
I have a daughter.
A daughter, I'm sorry. I have a son. I do that all the time. A daughter.
Yes.
Okay. And so you understand the court order?
Yes.
Okay. Did you show up on Thursdays?
Yes.
You did?
Yes.
And what did you do when you showed up?
Waited.
You did?
Yes.
Okay. And did you ask where he is?
No.
Okay. And so and he would text you at 4 the same days?
Yes.
And did you ever tell him, hey, I actually was there at 3?
No.
Okay. So you were intentionally trying to make sure that he didn't know the time.
No.
Okay. And you didn't give him to him on that weekend?
Not the days that he was late.
No, the day that he was on time
What day was that?
at 6 o'clock on Friday, when you said it wasn't even his weekend because it wasn't the calendar day. You remember that?
Yes, according to the order.
Like it's
he was
an
supposed to be
objection,
there.
non-responsive.
Sustain after yes.
Thank you. So you never intended to let him see your daughter. You're making it difficult for him to see your daughter. Is that true?
No.
But you were there at 3:15. You didn't bother to say, hey, I'm here.
No.
No further questions.
Okay.
Can I add something to that?
No.
Your attorney is about that. Whatever needs to be cleared up, he'll do it.
Okay.
Okay, go ahead, counsel.
Yeah, I was gonna say, do you want to clarify the last question opposing lawyer asking?
Go ahead, counsel. You may ask your question.
Yes, ma'am. Ms. Brooks, do you want to clarify anything in response to the question the opposing lawyer just asked you?
Can you repeat the question?
Yes, do you want to respond and clarify?
No, what question? Which one?
I'll move on.
Okay.
All right, so did you hear Mr. Slater say he never appeared at the time of his court-ordered possession begins?
Yes.
Okay, so we don't need to go through each text message showing he appeared at the wrong time because he just admitted it, right?
Yes.
All right. You've had to pay me a lot of money to defend this lawsuit.
Yes.
Not Ms. Caskey, but his another lawyer working for him, when they did the initial filing, didn't even include the time necessary to get you in trouble, right?
Yes.
We had to ask the court granted our request to make him specifically state the time that you allegedly violated the order, right?
Correct.
They ended up actually, after court order amending, correct?
Yes.
Okay, and now we're here in court, I think it's like 7 months later after the filing, conducting a trial for alleged violations he's admitted he didn't appear at the proper time for, right?
Yes.
Okay, what do you do for work?
I do DoorDash and I stay at home with my kids.
Okay, how old are you, ma'am?
26.
Okay, and how much do you make per year?
I'm not really sure. It varies.
Okay, is it well under 30,000?
Yes, sir.
Okay, is it under $20,000?
Yes, sir.
Do you know how much you paid me?
I would have to look it up, but it was a lot.
It's many thousands of dollars, right?
Yes.
We included some of your payments, which are $4,500 in our exhibits, right?
Correct.
And it's your understanding that more money is owed at this time?
Yes.
You're asking for him to pay your attorney's fees for bringing this, right?
Yes.
Do you believe the court's likely to deny his motion?
Yes.
Do you believe it's even close that the court will grant this motion?
No.
He came and admitted he didn't show up at the court ordered start time, right?
Yes.
Okay. He didn't even know that going into this. Is that correct?
Correct.
Meaning he filed a lawsuit against you seeking jail when he didn't even know the correct start time. Is that accurate?
Yes.
And has continued to refuse to drop it, right?
Yes.
They served discovery on you.
Yes.
We had to respond to that discovery.
Mm-hmm.
Part of that discovery was the school notification showing exactly when the school starts, when the school lets out, right?
Yes.
And Mr. Slater has still chosen to go forward with this lawsuit.
Yes.
You're asking for attorney's fees.
Yes.
This is real money you've had to pay, right?
Mm-hmm.
Out of your pocket.
Yes.
Have you borrowed money from anybody?
Yes.
Who'd you borrow money from?
My mother.
That's who you live with, right?
Correct.
And how much have you borrowed the entire amount from her?
Yes. Majority.
She wants it back, right?
Yes.
You need, that's real money you're gonna have to pay back to her.
Yes.
We conducted a phone call earlier this year, again, not with Ms. Caskey, but with another lawyer explaining the correct start time because he kept going at the wrong time, right?
Yes.
That was even after he.
I'd object to that because that's
Ju-
I mean, I wasn't there, so then it's like hearsay on what we might have told her. Like I wasn't there.
Well, she,
Well, he said it was another lawyer.
yeah, and she can testify what she said directly to him and his lawyer on the phone call. It's not settlement negotiations. We're telling them your client's going at the wrong time. So I don't think that falls under any objection.
Was she on the call?
Yeah, she
Yes,
was
I
on-
Well, if she can testify if she was on the call to what she said, not to what the attorney said.
Sure.
Okay, so overrule.
Did you, Ms. Brooks, I'm going to re-ask the question. Did you tell Mr. Slater and the lawyer, school doesn't let out at 4, it's lets out at 3:15?
Correct.
Okay, you're going at the wrong time.
Yes, I did.
After that phone call, it got cleared up, right?
Yes.
You started going at the right time. After that phone call,
No, he didn't.
he still kept going at the wrong time?
Yes.
Okay. Is it your responsibility in the order to explain what his obligations are?
No.
Does that seem to be lost on Mr. Slater?
Yes.
Is this indicative of what you've been dealing with co-parenting wise?
Yes.
Okay. There's other issues about your daughter that you'd prefer no makeup time, right?
Yes. Correct.
Is she acting out sexually at home?
Yes.
Section.
I'm going to
What's
say,
the legal objection?
I guess relevance. We're here on an enforcement, not on best interest.
Thing.
you'd ask the court, not a mortar makeup time, right?
Yes.
Part of that is because it's his fault for going at the wrong time,
Correct.
not yours.
Yes. Can I also make a comment?
What do you want to make a comment about, ma'am?
She mentioned about me not telling him the times and communicating with him. But I just want to be clear that I tried communicating with him before at the very beginning and I got attacked every single time. And instead of answering the question or coming to a conclusion, I can show the messages.
Can you explain the difficulties you had?
Yes, anything I've tried to communicate with them as far as the meetup and everything, I have tried to talk to them. I just don't do it over and over. I did it once, and then all I got was an argument. So I just stopped responding, unless it had something to do with my daughter. And even if it had anything to do with my daughter, all I got was an argument, or I got torn down by both of them in the text messages. It was never, they were never trying to come to a conclusion or a solution about anything.
You tried to work with him and his new.
Yes, multiple times I have. And they're saying I haven't, and I have. And it's not my fault that he did not know the time.
Sustain.
This is kind of consistent. Is his behavior consistent with the conduct during this lawsuit, that he's taking no responsibility for what he should be responsible for?
Yes,
Been very,
no responsibility.
it's been
And
very,
it's not my fault.
is it difficult? It has been difficult to deal with Mr. Slater?
Yes, very difficult. I try my best. It's very difficult.
Judge, I'm gonna pass it.
Okay. You said you try to communicate with him. Let's go through these exhibits.
Of course.
Exhibit 1,
Mm-hmm.
he says, I'm here. Do you respond?
No,
Okay, exhibit 2.
Hold on 1 second. We're referring to dad's exhibits?
Yes.
Okay, go ahead.
I don't have that as
Yeah, let me-
exhibits.
Oh, did you take them?
Yeah, he did.
Sorry, may I approach?
Yes.
Just FYI, those are our exhibits, so.
Yes.
Okay, he said dad exhibit. Okay.
So which one?
This one.
Okay, this is same one.
Yeah, so
It's
just
the same
pick
one?
pile. and
Okay,
then-
yeah,
There you go.
okay.
There you go.
Okay, so you don't respond in exhibit 1.
Yes, exhibit 1.
Let's go to exhibit 4. You don't respond.
I did respond to exhibit 4, and he did get his daughter in exhibit 4, and he said previously he did not. but he
Okay,
did.
let's go to exhibit 5.
Okay,
Did you respond?
no,
Okay, let's go to exhibit 6. Did you respond?
no,
Okay, let's go to exhibit 7. Did you respond?
no.
Okay, so do you think that you understand that he did his due diligence and he thought it was at 4, correct?
I want to mention that the.
Objection, non-responsive.
Sustain.
Yes or no? You heard that in court just now. He did his due diligence. He thought it was at 4. You heard that, correct?
Yes, he had the wrong time.
Okay, but you understand he didn't know that at the time. He did his due diligence to his understanding.
I believe he did know.
So is it just now that you're saying you showed up at 3:15 after this order was initiated?
No, and
Okay, objection, non-responsive.
Was she?
She said no. That's all I want.
Yeah, that was that. Overruled. That was the answer.
can I add to that?
No, she'll ask the next question.
Okay,
Exhibit 8, exhibit 9. Do you respond?
no,
Okay. Do you think if you would have responded, this would have been here today?
can you say that again?
If you would have just told him it was at 3:15 and you were there at 3:15, do you think he would have filed this lawsuit against you?
Probably.
Okay. And so was it your intention just to show up at 3:15 and never let him see the child on Thursdays?
No, it was my intention to show up at the right time, and if he can,
Objection, non-responsive, strike everything after no.
Sustain.
It's actually you, the one that can't communicate, is that right?
no,
And after you did communicate, he showed up on time.
Judge, I'm gonna object to relevance. I mean, on the scope of what we're here for, this is way beyond.
I think it is relevant because I think the violation is the court order and what they knew at the time and what their intent was. And her intent was to violate the court order and not let him see his child.
I'm going to sustain the objection and I get it.
Yeah, okay. Thank you.
Okay.
No further questions.
All right, counsel?
Yes, ma'am, do you believe you can get in trouble for appearing at a time that you weren't ordered to appear at?
no,
Okay, that seems to be the entire theory of Mr. Slater's case, right?
yes. And can I add something to that,
What would you
please?
like?
Yes, she's mentioning things from November, but the order started in June and we were having problems way before then with communication. And so I tried to limit the
Objection, Eric.
communication. No, there's no,
I think she's opened the door that my client can explain. prior.
Well, not narrative.
Okay, yes, ma'am. I'll pass the witness.
Anything further from this witness?
Nothing further.
Okay, ma'am, the text message that you were just looking at, the December 19th date,
What number was that?
let me go back. It is December, hold on.
I think two.
Exhibit. Hold on, I think I shrunk it. Exhibit 2.
Yes.
Is that you that sent the highlighted portion?
No.
That was
That's him. Okay.
Mm-hmm.
trying to abide by the court order.
Okay. Hold on 1 second. Let me. Okay, so you're in blue.
Yeah.
Yes.
Okay.
Yeah, it's in black and white for me.
And at the time of this December 19th, was the pickup time at 6 p.m. or was it when school got out?
It's still when school got out.
Okay.
Let's step up.
Was she getting out early?
My daughter was 3 years old at the time, so she wasn't in school. And so we were following the school that was closest to our home, or supposed to be.
Did they have pickup early or something that day? Or early dismissal because it was the holiday? Because I'm reading his message and it said, I will be at the designated location as specified in the court order tomorrow, Friday, December 20th at 12 o'clock noon. So I'm asking the school that is closest to your house, did they have early dismissal or something for him to think it was at noon?
Your Honor, I think the prior step-up order had him getting, was it a Saturday or a Friday? Just because he was at noon on Saturdays.
Oh, this is 24. That's right.
Okay, I think
And
that,
December 20th is not an alleged violation. The reason we included this is to show that the alleged violation is on December 19th. And so there's text messages on December 19th clearly showing he didn't show up at 3:15. They're talking about a different topic. It collaterally establishes that he didn't appear at 3:15. But it is discussing December 20th. That is correct.
Okay, that's where my confusion
Yeah.
was, because the dates don't match, the dates that are in the violation don't match up with the text messages.
Yeah,
That's where the
That-
confusion came
that
from
is,
me.
that's the one confusing one that's why we included it, because we think it shows, no, he didn't show up at 3:15.
Okay, so your daughter, does she go to daycare or she's with you?
My daughter's homeschooled.
Okay. And she gets out of homeschool following the school schedule that's closest to your house at 3:15.
Yes, at the time it was 3:15.
All right. Okay. What is it now?
It's 3:25 now.
And because you're homeschooling, you all are still doing pickups at the Dallas Police Department?
Yes.
All right. That's what I needed to know. Thank you.
I guess I have one question.
Go ahead.
Just, we didn't really cover it. You feel like the entire motion also fails because if you flip to exhibits 1, he was supposed to do 6 months of stair-stepped custom visitation, and he would get an SPO, right?
Correct.
And he missed a weekend
Yes.
during the 6 months.
Yes.
So ostensibly, he doesn't even have SPO right now.
Correct.
Because the order doesn't cover what happens if he misses a weekend, right?
Yes.
And exhibit 1 is him going late and not getting her for his weekend, right?
Correct.
It's not an alleged violation that he's alleging, correct?
Mm-hmm.
You're saying you missed the entire weekend during your 6-month step up.
Mm-hmm.
So SPO ostensibly doesn't even apply, right?
Correct.
And there's no provisions. Does the 6-month reset? Is it just a makeup? When is the date starting for SPO? Does he even have SPO if he misses time,
I
correct?
would object to this, because this is all legally questions that she wouldn't really have a fair understanding to answer this whole line of questioning.
Thing.
I'll pass the witness.
Anything further from this witness?
Nothing further.
Can I add something?
Ma'am, you may have a seat right there.
Okay.
Counsel, you may call your next witness.
I just call myself for attorney's fees.
Okay, go ahead.
Okay, we can stipulate? Okay, perfect. So we're stipulating to credentials, Your Honor. Our attorney rates at our office are $400 an hour. My rate is $300 an hour. Our associate attorney's rate is, or our law clerks and paralegals are $200 an hour. We spent approximately $4,200 on this hearing and preparing for this hearing. We had to prepare discovery, prepare exhibits, file our petition, show up to multiple courts. Hearings, the April hearing was reset not due to anybody, but due to, I think, unavailability that day. So it wasn't a fault to anybody else that were here today and not in April, because we were ready to go in April as well. We drafted the original motion for enforcement, discovery, prepping for the enforcement hearing, reviewing, and then just anticipated fees. So that's a total of $4,200 that we're asking the respondent to pay at this time. And that's it.
Thank you. Any cross?
No, ma'am.
Okay.
And I rest.
Okay, counsel?
Yeah, attorney, I'd call myself.
Okay, go ahead.
Judge, I have exhibit 13, which is a summary of my credentials, the time spent on this case, my hourly rates, and just kind of qualifies me as an expert. I think it's already been admitted, but I'd ask you to look at exhibit 13 if you have questions about qualifications. Really, I'd like to testify why you should give Ms. Slater fees. Judge, may I approach the bench and propose the orders?
With the affidavit?
No, with the proposed order.
Oh, okay.
This case should have never been brought. It's very clear.
And there's your jump drive back. Your jump drive.
Oh, thank you.
You're welcome.
This case never should have been brought. It's very clear. Mr. Slater has had many, many months to realize he doesn't have a case because he didn't go at the correct time. We've pointed it out to Mr. Slater numerous times. It's been hearing after hearing, appearance after appearance, discovery, answering discovery. Miss Brooks lives at home with her mother. She's in her 20s. This is real money that's costing her and the child. We'd ask you to assess attorney's fees against Mr. Slater. I don't believe it's even close that this should be granted, since the first thing he said when he took the stand is he admitted he didn't appear at the correct time. It appears he made no effort to figure out if he was appearing at the correct time. And it feels like the world, according to Mr. Slater, is Mr. Slater's world and everybody just kind of conforms to it. Well, that's not how it works when you have a custody order. He's supposed to appear at the correct time. The evidence has been overwhelmingly clear. He didn't. He's known about it for months, and yet still here we are going forward with this hearing. I think fees are more than justified against Mr. Slater in the amount in the proposed order. Thank you.
Thank you, counsel. Any cross?
No cross. I would like to do a quick closing.
Okay.
A minute.
If you think it's necessary.
Yeah, just a minute. So obviously, as you heard, he did follow the court order to the best of his ability. At the time, he believed that it was 4 o'clock. He called it. He did his research. He thought it was at 4. He showed up at 4 every single time, trying to abide by the order, trying to do the right thing, sending the court order to her. In response, Ms. Brooks did not communicate, did not respond, did not have any intention to ever follow this court order, and that needs to be addressed. He is a father, and then, I'm more concerned today hearing, again, new allegations. I think this is the very start of this, and this could go down a very dangerous path if mom is allowed to continue to not communicate and isolate dad, which is what I believe she's trying to do and what the evidence shows. Thank you.
Thank you.
I think we have an order on file, Your Honor, and I apologize that I don't have a printed off for you.
Okay, thank you. Counsel?
Yeah, I have nothing, Judge. I'll rest and close.
You both understand that enforcement motions are very serious, right? I'm talking to mom and dad.
Yes, ma'am.
Y'all understand that, right? And they become even more difficult when they're not followed for trivial reasons, right? And what do I mean by trivial? unless your daughter is in danger and there is a danger that you know at the time, everybody should follow the court order to the best of their ability. Counsel, I have one question for you. To your knowledge, did she have a conversation with Attorney Faust about the time that the child gets out of school?
No, not to my knowledge.
Okay, so you don't know if it happened.
No, but to my knowledge, after he realized it was 3:15, I know there was testimony opposed to that, but he's been showing up at 3:15 ever since he learned.
And learned.
Okay, oh, and let me say this before we go any further. The order is silent about what happened if he missed any visits or anything like that, and the court is going to go by the order in strict compliance with it. Do you all live within 50 miles of each other?
No, I don't believe so.
Yes, we do.
Yeah, where you live?
Mesquite.
Where do you live?
Corny.
Yeah, you all live within 50 miles. So,
Oh, I thought you said.
no. So the court order already tells you exactly what you're supposed to do right now. So because I don't want either one of you walking out of here not knowing what your court order says. It specifically says that if you all live within a 50-mile radius of each other, it outlines what your possession and access is supposed to be every week. It's on, well, this order isn't numbered. But it says parents who reside within 50 miles or less, except otherwise explicitly provided, if Matthew Lee Slater resides 50 miles or less from the primary residence of the child, the parent shall have the rights and possession of the child as follows, and it outlines that you've seen it, you know what it looked like. So, you know, it starts when school regularly dismisses,
Yeah.
right? Ma'am, what time does school regularly dismiss?
The new school is 3:25.
3:25, so you have that.
Yes, ma'am.
Are you all confused about where you're supposed to exchange?
Yes, I do want to make a comment because we're supposed to meet at the police station,
Yes,
but they like to walk up to my car, and I told them before I don't feel comfortable with that, and they keep doing it instead of letting us meet inside of the designated area. They keep trying to walk up on me, and I don't like that. I don't feel comfortable.
okay, so the
So can we
order
make sure that
doesn't.
it's on the inside and not around my car. Like,
Okay, so this order, it doesn't explicitly state. It just says the Dallas Police Department. If she's saying she doesn't feel comfortable with you walking up to the car, just don't walk up to her car.
Yes, ma'am. We actually wait on the inside. She wait until like minutes after the transfer time, still calling her back in the car and
Mhm.
holding on to her and stuff. So we walk outside of the police station and let her know, hey, we're out here. What are you doing? Let's go. You know what I'm saying? Go on, let's
Y'all just exchange in the lobby.
Yeah.
Just make it
Yeah.
easy. Exchange in the lobby, because if you're in the lobby, there are cameras and there are police officers there. But so if anything transpires, I'm going to know for sure who did what,
Right.
and there is no discrepancy. All right. The reason that and let me just say, I don't think that either. When was the last time you seen your daughter?
This past Thursday.
Okay. So I don't think that Mr. Slater intentionally did not comply with the order. And I know that I don't believe you did it intentionally, because if you did, you wouldn't have given the testimony that you did. Your testimony was honest. I honestly believe that whatever conversation between you and your attorney, you were not advised 100% about what this order actually says, okay? And because of that, and because this order, the way that it is written, the law says that it has to be in strict compliance with the violations. If there is no strict compliance, I cannot hold her in contempt. And I also cannot find that she violated this court order. Does that make sense?
Yeah.
So with that being said, I cannot find that she violated the court order. I'm not going to say that you shouldn't have brought the order, just like I wouldn't tell you not to bring the order. Okay, I don't need that, counsel. I don't need that. Just like I'm not going to tell you not to bring an order. I'm not going to tell either one of you to do that, because if either one of you are not following the court order, whether it's possession and access or child support, you do need to bring that to the court's attention. So I don't want anybody to be discouraged. So I'm not gonna find her in contempt. I cannot find her in contempt. I cannot find that she violated the order because the way that this motion is written, it doesn't allow me to do so. All right? With that being said, just follow the court order. If you all follow the court order as is written to the best of your ability as is written, that's all you're responsible for. Anything that's not enforceable, you have attorneys to bring that to my attention, and there are things that I can do to do that. And because the order is not, because the motion is not specific the way that it needs to be, I think awarding attorney's fees to mom would be punitive to dad. And I don't believe that's fair. So each person is going to walk away today paying their own attorney's fees. They know what their responsibilities are under the court order. If you all come back in here moving forward, then I know that we're going to have an issue because I just explained it to you. You understand what the order says. Do you have any questions for me, Mom?
Yes.
Go ahead.
So he was on the phone call and he still came at the wrong time. I just have questions because it seems like he's able to make numerous mistakes all the time and he's never held accountable, but it's always making me look like the bad person. When he was on the phone, he got the exact time. She was on the phone too, the lady in the green. She was also on the phone. They got the time and they still showed up at the wrong time. And this was after the court date. They were still appearing at the wrong time. And I even told them that.
Yeah, but let me say something to you. He didn't make you look bad today. Neither one of you look bad. And let me explain something to you. Y'all are parents. I have 2 kids. I have a 16-year-old and a 16-year-old. I get it wrong every single day. Every day. I'm still trying to figure out parenting. It's not easy at all. You're always going to make a mistake. You are always going to get it wrong. I don't want either one of y'all to walk out of here and think that you're going to get it right. Judge or no judge, I still mess up. And I'm still figuring out. Is it Aura? Aura is 4 years old. Y'all had the rest of y'all life to figure it out. And even figuring it out, you're still gonna get it wrong. Okay? So I don't want you to walk out of here and think that I'm looking at you a certain type of way. I look at you as a parent, as I'm a parent. I look at you like I'm a parent. I don't look at you any other way. Okay? Legally, there are things I can and cannot do. All I want you all to do is when you walk out of here today, learn how to co-parent because I kid you not, y'all are going to need each other more than ever. And you only going to have each other to depend on. I know you have your mom, you have the support of your family. Huh? Your wife, you have the support of family, both of you. But at the end of the day, the mistakes and the things that are done right are going to fall back on the parents. And that's what I want y'all to do. I want y'all to work together and be good parents. If you can't figure it out, that's what I'm here for. But I don't want to do anything to either one of you today that's going to be punitive. I don't think that's fair. So you each pay your own attorney's fees. Is there anything further?
Judge, if you strike the bottom 2 paragraphs, the order denying, the bottom 2 paragraphs have to do with my attorney's fees. So I think if you cross those out, I think we can walk out here with an order.
Okay. Did you e-file this?
I'm pretty sure I did.
Okay, let me double check. Because if you e-filed it, it'll probably be cleaner
Okay.
if I do it on,
It would have been my paralegal.
yeah, I'll just do the order. It'll be short.
Okay.
So I'm signing the order today, denying anything. Wait a minute, I asked her, did you have any questions for me?
Not really questions, but in the whole point of it, just wanted to the time back of getting with Aura. My wife and I just want a good co-parenting thing. We don't have to be friends or anything, but communication is one of the main things. You know what I'm saying? Figuring out what's best for Aura and how we gonna do this. You know what I'm saying? So that's the only part. When once I filed, then we start getting the right time on when we were supposed to pick up Aura, and then we start getting her on Thursdays. We was cool with that because it's there. But getting that back time, of course, we needed that because I've already been strict with her and everything like that.
So because I denied the motion in its entirety, because of the violation, the way that the violations are written, I can't even award back time. But you know what? We're going to move forward because moving forward, you're going to pick up when you're supposed to pick up. You know the time. You're gonna exchange when you're supposed to exchange, you know the time, and y'all gonna do it in the lobby, remember?
Yeah.
Don't go to each other's cars, just do it in the lobby. Okay? Do either of you have a question for me before you walk out of here? I wanna make sure everybody is on the same page. Now's the time to ask.
And then there's also, I was looking at CPS charges.
Mm-mm. Mm-mm.
Let me get this going. Yeah.
Anything else about the order itself? No? Okay.
Are we allowed, since she? I don't know.
Ask the question. I don't want anybody to walk out of here confused.
Yeah, ask her. She's giving you a chance.
No, it's fine. I just say report modification.
Okay. And you all can do that. You know you can modify the order as much as you need to.
Yes.
Okay. Y'all have a good day.
Thank you.
You're welcome.